Have certain physical objects deemed or marked for identification before the trial begins, and you will then hear the lawyer refer to the object by its number or letter. An item deemed or marked for identification is not evidence and is, therefore, not available for your inspection and consideration. It's only the objects that are actually received into evidence that are evidence. Sometimes a lawyer will ask the court to receive an object in evidence, and when a lawyer does that, the other lawyer is permitted to ask the witness questions designed to determine whether the object can, under the law, be admitted into evidence. Again, if I grant the request to admit the object in evidence, the object becomes evidence and is available for your inspection and consideration. I advise you that it is common and permissible for a lawyer or an investigator for a lawyer to speak to a witness about his or her testimony before calling him or her to the stand. Also, a witness may review documents and other material pertaining to the case before he or she testifies at the trial. Generally, a witness scheduled to testify at trial may not be present in the courtroom during the testimony of other witnesses, but there are exceptions. After the people have completed the presentation of their evidence, the defendant may, but is not required, to present evidence. I remind you that throughout these proceedings the defendant is presumed to be innocent. As a result, must find the defendant not guilty unless on the evidence presented at this trial you conclude that the people have proven the defendant guilty beyond a reasonable doubt. That a defendant does not testify as witness not a fact from which any inference unfavorable to the defendant may be drawn. The defendant is not required to prove that he is not guilty. In fact, the defendant is not required to prove or disprove anything. To the contrary, the people have the burden of proving the defendant guilty beyond a reasonable doubt. That means before you can find the defendant guilty of a crime, the people must prove beyond a reasonable doubt every element of the crime, including that the defendant is the person who committed that crime. The burden of proof never shifts from the people to the defendant. If the people fail to satisfy their burden of proof, you must find the defendant not guilty, and if the people satisfy their burden of proof, you must find the defendant guilty. The law uses the terms, proof beyond a reasonable doubt, to tell you how convincing the defendant's guilt must be to permit a verdict of guilty. The law recognizes that in dealing with human affairs there are very few things in this world that we know with absolute certainty. Therefore, the law does not require the people to prove a defendant guilty beyond all possible doubt. On the other hand, it is not sufficient to prove that the defendant is probably guilty. In a criminal case, the proof of guilt must be stronger than that, must be beyond a reasonable doubt. A reasonable doubt is an honest doubt of the defendant's guilt for which a reason exists based upon the nature and the quality of the evidence. It is an actual doubt, not an imaginary doubt. It is a doubt that a reasonable person acting in a matter of this importance would be likely to entertain because of the evidence that was presented or because of the lack of convincing evidence. The proof of guilt beyond a reasonable doubt is proof that leaves you so firmly convinced of a defendant's guilt that you have no reasonable doubt of the existence of any element of the crime or of the defendant's identity as the person who committed that crime. In determining whether the people have proven the defendant's guilt beyond a reasonable doubt, you should be guided solely by a full and fair evaluation of the evidence. After carefully evaluating the evidence, each of you must decide whether that evidence convinces you beyond a reasonable doubt of the defendant's guilt. Whatever your verdict may be, it must not rest on baseless speculation, nor may it be influenced in any way by bias, prejudice, sympathy, or by a desire to bring an end to your deliberations or to avoid an unpleasant duty. Again, if you are not convinced beyond a reasonable doubt that the defendant is guilty of the charged crime, you must find the defendant not guilty of the crime, and if you are convinced beyond a reasonable doubt that the defendant is guilty of a charged crime, must find the defendant guilty of that crime. Now, when each witness, by whomever called, is first examined, that is, they are asked questions by the lawyer who calls the witness to testify, that is called direct examination. When the direct examination is completed, the other lawyer is permitted to ask questions of the witness, and that is called cross-examination. The lawyers are responsible for questioning the witnesses. The court may at times ask a witness a question. The jurors may not ask questions of the witnesses. You may, but are not required, to take notes. You wish to take notes, we will provide materials to you for that purpose. If you decide to take notes, you must follow these rules. Remember, every word of each witness is recorded by the court reporter, and during deliberations upon your request the testimony will be read back to you in whole or in part. So there is no need to take verbatim notes of a witness testimony. Notes by definition are a brief written record of something to assist your memory. A note should not take precedence over your own independent recollection. Remember, also, you are the finders of fact who are responsible to evaluate the believability and accuracy of a witness testimony. It is, thus, important that you be able to both fully comprehend what a witness is saying and how a witness is saying it. Accordingly, you must not permit note-taking to distract you from the proceedings. If you make a note, it should be brief and not distract you from what the next question and answer are. Any notes a juror takes are only for that juror's own personal use in refreshing his or her recollection. Thus, jurors who chose not to take notes must rely on their own independent recollection and must not be influenced by any notes another juror may have taken. Also, a juror's notes are not a substitute for the recorded transcript of the testimony or for any exhibit received into evidence. If during your deliberations there is a discrepancy between a juror's recollection and his or her notes regarding the evidence, you should ask to have the relevant testimony read back or the exhibit produced for your inspection. At the end of each day, you will leave your notes on your chair. They will be collected and safeguarded here, and at the end of trial they will be destroyed. As judges of the fact, you alone determine the truthfulness and accuracy of each witness. You must decide whether a witness tells the truth and was accurate or instead testified falsely or was mistaken. You must also decide what importance to give to the testimony you accept as truthful and accurate. Is the quality of the testimony that is controlling, not the number of witnesses who testified. There is no particular formula for evaluating the truthfulness and accuracy of another person's testimony or statements. You bring to this process all of your varied life experiences. In life, you frequently decide the truthfulness and accuracy of statements made to you by other people. The same factors used to make those decisions should be used in this case when evaluating the testimony. At the end of the trial, I will give you some examples of those factors. There are rules for all stages of a trial, including rules that govern whether certain evidence may be introduced and, if so, how and when. Part of my job is to enforce those rules. Of these rules, you may understand the nature of the rule, but some of them you may not understand unless you studied the law. The rules have been carefully developed over hundreds of years for the sole purpose of guaranteeing a fair and orderly trial. In other words, the rules are not designed to determine whether the evidence you hear and see is true or false, accurate or inaccurate. It is for you, not for me, to evaluate the evidence and make those decisions. The rules are designed to ensure that the evidence you hear and see is relevant and in a form that permits you to evaluate it fairly. A witness usually can testify only about matters the witness has personal knowledge of, that is, something the witness has personally seen, heard, felt, touched, or tasted. Thus, a witness is not permitted to guess or speculate or say what he or she thinks another person saw, heard, felt, touched, or tasted. Also, a witness is not permitted to give an opinion about matters for which a special expertise is necessary unless, of course, the witness purports to be an expert on the matter he or she is being questioned about. Whereupon, principal court reporter Susan Pierce Bates was relieved by senior court reporter Lisa Kramsky. The court, with some exceptions, what a witness may have been thinking when something has taken place is not relevant evidence. Finally, a witness is often not permitted to testify to hearsay, meaning generally that a witness cannot testify to what the witness may have said before the trial, or what another person may have said to that witness before the trial. But there are many exceptions to the hearsay rule for a variety of sound reasons, too numerous to go into at this time. I will, however, explain a couple of exceptions that frequently arise during a trial. Sometimes a witness will be permitted to testify that the witness did something because of what someone said in that circumstance. It does not matter who uttered the statement or how the speaker gathered the information for the statement, or even whether the statement is truthful and accurate. It matters only that someone uttered the words and the witness did something upon hearing those words. So in that instance, you may not consider what the witness was told for the truth of the words said to the witness. You may consider the words only for the reason they are offered, that is, to explain what the witness did after hearing the statement. During the presentation of evidence, the lawyers for the parties will in turn ask questions of the witnesses, and during that questioning a lawyer is not permitted to make comments on the witness's answers or on the case. That is not allowed. That happens on TV and in the movies, but it doesn't happen in real trials. In a real trial, it is at the end of the case that the lawyers are permitted to address the jurors in what are called summation, and it is then that the lawyers may comment on the witnesses, the testimony, and any other evidence. During the questioning of a witness, the lawyer may use a question or some other presentation of evidence. If not in accord with a rule of law, that lawyer will object. When an objection is made, I will decide whether the rules permit the question to be asked or the evidence to be introduced. The objection will be one word, objection. Anything more than that, then a party might gain an unfair edge. Making objections is part of the lawyer's job. Are not to draw any unfavorable inference because objections are made, they take place at every trial. A lawyer may object before a witness answers question or after a witness answers a question. When an objection is made to a question before the witness answers, if I overrule the objection, the witness will be permitted to answer. If I sustain the objection, there is no answer and, therefore, no evidence. Remember, a question alone is not evidence. If a lawyer objects after the witness has answered the question and I overrule the objection, the answer stands as evidence. If I explain the objection, the answer is not evidence. The question and answer is stricken from the record, and you are to completely disregard that answer though it were never said. Also, the court has an obligation under the laws of New York to make sure that fundamental rules are followed, even if one of the lawyers does not actually voice an objection. So, on occasion, you may hear me say sustained or words to that effect, even though no one has actually objected. Any ruling by the court on an objection of counsel or otherwise is based on our law and expresses no opinion about the facts of the case or whether the defendant is guilty or not guilty. Remember, you are responsible for making that decision. Now, from time to time during the course of the trial, there will be conferences at the bench with counsel, and if they become prolonged, it may be necessary for the court to ask the jury to return to the jury room. These conferences that deal with questions and matters of law and scheduling of the trial are my responsibility, so when the occasion arises when there are conferences at the bench or outside of your presence, I ask for your understanding. Upon completion of the presentation of evidence, the lawyers will address you in a closing statement, or what the law calls a summation. What a lawyer says in a summation is not evidence. The summations, however, provide each lawyer an opportunity to review the evidence presented and submit for your consideration the facts, inferences, and conclusions which they contend may be properly drawn from the evidence. After summations are concluded, I will instruct you on the rules of law applicable to the case. You must accept and follow those rules. You will then begin your deliberations. During your deliberations, your function as jurors will be to decide what the facts are and to apply the rules of law that I set out. You will determine what the facts are from all of the testimony that you hear, the exhibits that are submitted, and any stipulations the parties have agreed to. In other words, you will decide the case on the evidence. The conclusion you reach from determining the facts and applying the law will be your verdict, guilty or not guilty. Remember, you have promised to be a fair juror. A fair juror is a person who will keep their promise to be fair and impartial and who will not permit the verdict to be influenced by bias or prejudice in favor of or against the person who appeared in this trial on account of that person's race, color, national origin, ancestry, gender, gender identity or expression, religion, religious practice, age, disability, or sexual orientation. And, further, a fair juror must be mindful of any stereotypes or attitudes about people or about groups of people that the juror may have, and must not allow those stereotypes or attitudes to affect their decision. As I explained during jury selection, we all develop and hold unconscious views on many subjects. Some of those unconscious views may come from stereotypes and attitudes about people or about groups of people that may impact on a person's thinking and decision-making without that person even knowing it. As a juror, you are asked to make a very important decision about another member of the community. I know you would not want to make that decision based on such stereotypes or attitudes, that is, on implicit biases. And it would be wrong for you to do so. A fair juror must guard against the impact of such stereotypes or attitudes. You can do this by asking yourself during your deliberations whether your views and conclusions would be different if the defendant, witnesses, or others that you have heard about or seen in court were of a different race, color, national origin, ancestry, gender, gender identity or expression, religious practice, age, political affiliation, or sexual orientation, or if they did not have a disability. If the answer is yes, then in keeping with your promise to be fair, reconsider your views and conclusions along with the other jurors, and make sure your decision is based on the evidence and not on stereotypes or attitudes. Justice requires no less. Under our law, juror number 1 will serve as the jury's foreperson. During the trial, the foreperson has the same responsibilities as any other juror. During deliberations, the foreperson will sign any note that the jury sends to me, including that the jury has reached a verdict. The foreperson will announce the jury's verdict. Thus, in sum, the stages of the criminal trial are the opening statements, the presentation of evidence, summations, the final instructions of the court to the jury on the law, and the deliberation of the jury and the verdict during the trial. If you need to speak with me about something relating to your jury service or the trial, please tell a court officer that you need to speak to me. I will then arrange a meeting with the parties, in the courtroom or in my robing room. Do not discuss with your fellow jurors whatever you feel necessary to bring to my attention. And after we have had our conversation, do not discuss with your fellow jurors whatever it is that we discussed. During the trial, we do our best to avoid delay, but from experience I know delays are inevitable for a multitude of reasons, through no one's deliberate fault. When those delays occur, I ask for your understanding and your patience. I assure you your time is important to me. I never take it for granted, and I never want to waste it. I request that you please be here at the times I set so that the absence or lateness of a juror is not the occasion for delay. If an emergency arises that may make you late or prevent you from attending, please call the court, leave a number where you can be reached and explain the problem so can minimize everyone's inconvenience. In this case, we have 6 alternate jurors. An alternate juror is expected to pay the same close attention to the case as any one of the first 12 jurors. The only difference between an alternate juror and one of the first 12 jurors is that the alternate juror does not know whether that juror will be called upon at some point during the trial to substitute for one of the 12 jurors. That substitution could take place only if some presently unforeseen extraordinary emergency arises that makes it totally impossible for one of the first 12 jurors to complete the trial. Our law expects that the first 12 jurors who begin the trial will be the same 12 jurors who complete the trial, so it takes an extraordinary emergency before there may be a substitution of an alternate. Finally, our law requires jurors to follow certain instructions in order to help assure a just and fair trial. And I am required by law to read these admonitions to you whenever we separate. You will hear them countless times during the course of the trial. I will now give you those instructions. Do not speak either among yourselves or with anyone else about anything related to the case. You may tell the people with whom you live or your employer that you are a juror and give them information about when you will be required to be in court, but you may not talk with them or anyone else about anything related to the case. Do not at any time during the trial request, accept, agree to accept, or discuss with any person the receipt or acceptance of any payment or benefit in return for supplying any information concerning the trial. You must promptly report directly to me any incident within your knowledge involving any attempt by any person to improperly influence you or any members of the jury. Do not visit or view the locations or places that a charged crime was allegedly committed or any other premises or place involved in the case. And you must not use Internet Maps, Google Earth, or any other program or device to search for and view any location discussed in the testimony. Do not read, view, or listen to any accounts or discussions of the case reported by newspapers, television, radio, the Internet, or any other news media. Do not attempt to research any fact, issue, or law related to the case, whether by discussion with others, by research in a library or on the Internet, or by any other major source. I want to emphasize that in addition to not speaking face-to-face with anyone about the case, you must not communicate with anyone about the case by any other means, including by telephone, text messages, email, chat rooms, blogs, social websites such as Facebook or X. And you must not provide any information about the case to anyone by any means whatsoever, and that includes the posting of information about the case, or what you were doing on the case, on any device or anything outside the case, including chats, blogs, social websites, or any other means. You must also not Google or otherwise search for any information about the case or the locations involved in the case or the people involved in the case, including the defendant, the witnesses, the lawyers, or myself. Now, jurors, I want you to understand why these rules are so important. Our law does not permit jurors to speak with anyone else about the case or permit anyone to talk to them about the case because only you are authorized to render a verdict. Only you have been found to be fair, and only you have promised to be fair. No one else has been so qualified for this trial. Our law also does not permit jurors to speak among themselves about the case until the court tells them to begin their deliberations, because premature discussions can lead to a premature final decision. Our law does not permit you to visit a place discussed in the testimony. First, you cannot always be sure that the place is in the same condition as it was on the day in question. Second, even if it were in the same condition, once you go to a place discussed in the testimony to evaluate the evidence, in light of what you see, you become a witness, not a juror. As a witness, you may now have an erroneous view of the scene that may not be subject to the correction by either party. That would not be fair. Finally, our law requires that you not read or listen to any news accounts or posts of the case, and that you not attempt to research any fact, issue, or law related to the case. Your decision must be based solely on the testimony and other evidence presented in this courtroom. It would not be fair to the parties for you to base your decision on a reporter's view or opinion or upon information that you acquire out of the courtroom. These rules are designed to help guarantee a fair trial, and a violation of any of these rules can jeopardize the integrity of these proceedings. Accordingly, our law sets forth serious consequences if the rules are not followed. I trust you understand and appreciate the importance of following these rules. And in accordance with your ultimate promise, I know you promise to do so. Before we begin with the opening statement, I know we briefly discussed scheduling.